The Trump administration just joined a lawsuit against UCLA Medical School, and at first glance, that might sound like something that law school applicants can safely ignore. But that would be a mistake, because what happened in that case didn't just affect a medical school, it has quietly changed how every single law school admissions office in the country now has to think, even if no law school is ever actually sued. And that's the part almost nobody is explaining clearly. So let me walk you through it. Here is what actually happened. The Department of Justice didn't just criticize UCLA or issue guidance or send a warning letter, they joined a lawsuit. And by doing that, they have forced the release of internal admissions data, real numbers across multiple years, showing how test scores lined up across different groups. And that is the key moment here, not the lawsuit itself, but the data. Because for decades, elite professional schools operated under a quiet assumption. They believed their internal admission spreadsheets, the stuff they never publish, was basically private unless they lost a massive court case, and that assumption is now gone. UCLA didn't lose first. The government just stepped in, and suddenly the data was public, and that changes the rules. Now, here's where law schools come in. Law schools, of course, don't use the MCAT, they use the LSAT. It's a different test, but it has the same role, it functions the same way. And law schools are already under intense numerical pressure. The rankings, the median, scholarship competition, yield management. Every law school already has internal dashboards showing who they admit, who they deny, who gets scholarship money, and how all of that lines up with LSAT scores. But they don't publish that data by choice, of course. But now they have to assume the federal government could see it at some point in the future. And once that assumption exists, their behavior is going to change fast. And this is what applicants never see. After something like the UCLA lawsuit happens, general counsel doesn't sit around waiting. They email admissions. And the question is not, are we technically compliant? The question is, what does this look like if someone asks for our data? And that single question reshapes everything, not publicly or dramatically, but quietly. Now, here's the first real consequence. Borderline applicants are going to get squeezed. Law schools don't eliminate discretion, they reduce risk. So you start seeing narrower LSAT ranges, fewer exceptions, and less willingness to stretch below the medians. If you are below a school's LSAT median, you're no longer just competing against other applicants, you're competing against the school's tolerance for public scrutiny. Now, and secondly, and this is huge, scholarships tighten before admissions does. Scholarship data is much harder to defend than admissions offers. If two applicants look similar on paper, but get wildly different aid, that's easy to question later. So schools respond by tightening LSAT cutoffs for big scholarships, reducing discretionary awards, and standardizing their aid bands. Which means this: a higher LSAT doesn't just help you get in, it protects your scholarship leverage. And that matters more now than it did even a couple of cycles ago. Now let's talk about holistic review, because this part gets misunderstood. Law schools will say they do holistic review, and that's true, but the space where holistic review operates is shrinking. Think of it like this: numbers decide whether you're safe, but holistic factors decide who gets picked within the safe group, and that is a subtle change. But it's a massive one for applicants who are counting on their stories to compensate for lower numbers. Of course, stories still matter, but they matter after the numbers clear the risk threshold, after the numbers bring you above a certain bar. So why is this happening now? Because the Supreme Court has already banned race-based admissions preferences, but what's happening now is enforcement through exposure. The government doesn't need to sue every single university, and it doesn't need to win every single case. They've just got to show they can see inside the process. And once that's clear, the institutions will adjust on their own because it's faster, it's cheaper, and it works. And law schools understand this immediately. And law schools specifically are pretty sensitive, vulnerable targets because they train judges, they feed regulatory agencies, and that makes them visible. And that makes them cautious. So what does this mean for you practically as an applicant? If you're applying to law school in the next couple of years, The reality is that law schools are becoming more risk averse. And risk averse schools don't make gambles on borderline numbers unless they absolutely have to, which means that being above the median matters more, their margins are going to be tighter, and being interesting but risky is going to be a harder sell. Of course, this doesn't mean personal statements don't matter, but it means they work best on top of already strong numbers, not as a substitute for those numbers. So here's the takeaway I want you to actually act on. In an environment where law schools fear scrutiny, numbers protect everybody. Your LSAT is still the cleanest, safest, most defensible signal in the entire process. And when institutions are optimizing for defensibility and safety, that signal is going to carry more weight, not less, because the real fallout from this UCLA med school lawsuit is not another headline, it's the quiet shifts with all the other graduate schools watching this, happening behind the scenes. And by the time that most applicants realize the rules changed, the cycle's already going to be over.